Breaking news in the immigration world today, and this is information that could directly affect you or someone you know. A federal judge has just issued an order blocking certain deportation operations under the Trump administration. And if you are currently in removal proceedings, have a pending case, or know someone navigating the immigration system right now, you need to understand exactly what this means, what it doesn't mean, and what steps you should be taking to protect yourself and your family. I'm going to walk you through this development step by step, explain the legal context behind it, clarify who is affected and who is not, and give you concrete actions you can take right away to stay informed and prepared. This is immigration news today, and whether you're a green card holder, someone with a pending application, or a family member supporting a loved one through the immigration process, stay with me because this ruling has immediate implications. So let's start with what actually happened. A federal district court judge issued a temporary restraining order halting certain immigration enforcement operations that were part of a broader directive from the White House. Now, the specifics of this order are critical, so I want to be very clear about the scope. The judge did not issue a blanket ban on all deportations nationwide. What the court did was block specific enforcement actions targeting certain categories of individuals, particularly those with pending applications for relief, those who have ongoing appeals, and in some cases, individuals who were picked up in operations that the plaintiffs argued violated due process protections. This is a temporary measure, meaning it's not a final decision on the merits of the case, but rather a pause while the court examines the legal arguments more thoroughly. The order is currently in effect, but as with all litigation in the immigration space, this could be appealed, modified, or extended, depending on how the case progresses in the coming days and weeks. Now, let me give you some background so you understand why this is happening. The Trump administration, upon taking office in January 2025, signed a series of executive orders dramatically expanding immigration enforcement priorities. Unlike previous policies that focused enforcement resources primarily on individuals with serious criminal convictions or recent border crossers, the new directives broadened the net to include virtually anyone in the United States without lawful status, as well as certain categories of individuals with pending cases or temporary protections. The administration also moved to ramp up worksite enforcement, increase cooperation between local law enforcement and federal immigration authorities, and accelerate removal proceedings across the board. These policies led to a surge in arrests and a sharp increase in individuals being placed into removal proceedings or fast-tracked for deportation. Civil rights organizations, immigrant advocacy groups, and several states quickly filed lawsuits challenging the legality and constitutionality of these enforcement actions, arguing that they violated due process, exceeded executive authority, and in some cases, targeted individuals based on national origin or other protected characteristics. The court order we're discussing today is one outcome of this litigation. The judge's reasoning, based on court filings and preliminary statements, centered on several key concerns. First, the court found that certain individuals who were detained or scheduled for removal had not been given adequate notice or an opportunity to present their cases, which raises due process issues under the Fifth Amendment. Second, the court expressed concern that the accelerated pace of enforcement was leading to errors, including cases where individuals with valid claims for relief or individuals who were legally present were being swept up in operations. Third, the plaintiffs presented evidence that some enforcement actions were being carried out in a manner inconsistent with existing regulations and agency guidance, potentially exceeding the administration's legal authority. The judge concluded that these concerns were serious enough to warrant a temporary halt to the challenged operations while the case proceeds. It's important to note that this ruling is preliminary. The government has the right to appeal, and higher courts may weigh in. As of the date I'm recording this, which is early February 2026, this order is active, but the legal landscape can shift quickly. So who does this order actually protect, and who does it not protect? This is where you need to pay very close attention because the language of court orders can be technical, and misunderstanding the scope could lead to dangerous assumptions. Based on the information available from court documents and reporting by credible outlets including Reuters, the Associated Press, and the New York Times, the order appears to apply to individuals who fall into one or more of the following categories. First, individuals with pending applications for asylum, adjustment of status, temporary protected status, or other forms of relief who were scheduled for removal before their applications were adjudicated. Second, individuals who have filed appeals with the Board of Immigration Appeals or federal courts and whose cases are still pending. Third, individuals who were detained in enforcement operations that are specifically named in the lawsuit, particularly those operations that plaintiffs argue were conducted without proper warrants or legal authority. Fourth, in some instances, individuals who have long-standing ties to the United States, such as decades of residence, U.S. citizen family members, or other equities that the court found warranted additional review before removal. The order does not, however, provide blanket protection to everyone in the immigration system. Individuals who have final orders of removal that were issued after full proceedings and exhausted appeals, individuals with serious criminal convictions for violent crimes or other aggravated felonies, and individuals who were apprehended at the border attempting unlawful entry are generally not covered by this temporary restraining order. Additionally, the order does not prevent Immigration and Customs Enforcement, or ICE, from conducting arrests or placing individuals into removal proceedings. What it does is pause the actual physical removal, the deportation itself, for those who fall within the protected categories while the court examines the legal challenges. This distinction is crucial. If you or someone you know is in immigration proceedings, this order may buy time, but it is not a permanent solution, and it does not eliminate the underlying case or the need to pursue relief through the proper legal channels. Now let's talk about what you should do if you think this ruling might affect you or a loved one. First, and most importantly, if you are currently in removal proceedings or have a pending immigration case, you need to consult with a qualified immigration attorney immediately. I cannot stress this enough. Every case is different, and while this court order may provide temporary relief for some, it does not change the fact that you need a legal strategy tailored to your specific situation. Many nonprofit organizations and legal aid societies offer free or low-cost consultations for individuals in removal proceedings. You can find referrals through the American Immigration Lawyers Association, or AILA, and through the Executive Office for Immigration Review's list of pro bono legal service providers. Do not rely solely on social media posts or secondhand information about this ruling. Get professional advice from someone who can review your case file and explain your options. Second, if you have a pending application for any form of relief, whether it's asylum, adjustment of status, a U visa, a T visa, DACA renewal, TPS registration, or anything else, make sure that application is complete, up to date, and that you have proof of filing. Keep copies of all receipts, notices, and correspondence from USCIS, Immigration and Customs Enforcement, or the Immigration Court. If you have an attorney, make sure they have the most current contact information for you and that you respond promptly to any requests for additional evidence or information. If your case is with the Immigration Court, check your hearing date and make absolutely sure you appear. Missing a hearing, even in light of this court order, can result in an in absentia removal order, which is much harder to reopen. Third, if you have a final order of removal but believe you may qualify for a motion to reopen, a motion to reconsider, or a stay of removal based on changed circumstances or new evidence, now is the time to explore those options with an attorney. The current legal environment is creating opportunities for some individuals to present arguments that were not available or were not as strong under previous policies. For example, if you were ordered removed years ago but have since developed strong equities in the United States, such as U.S. citizen children, a serious medical condition, or other compelling humanitarian factors, a motion to reopen might be worth pursuing. The court order we're discussing today does not automatically grant relief, but it may provide a window of time during which you can take action. Fourth, if you are a green card holder or someone with lawful status, but you have family members who are undocumented or in removal proceedings, there are steps you can take to support them. If you are a U.S. citizen or lawful permanent resident, you may be able to petition for certain family members. The process can be lengthy and complex, particularly if the family member is already in removal proceedings. But it is possible in some cases to halt removal through a petition and a request for prosecutorial discretion or a stay of removal from the immigration judge. Again, this requires working with a qualified attorney who understands both family-based immigration and removal defense. Fifth, stay informed about updates to this case and related litigation. Court rulings can be appealed, modified, or overturned, and new developments can happen quickly. Reliable sources for updates include the official websites of USCIS, U.S. Customs and Border Protection, and the Executive Office for Immigration Review. Credible news outlets such as Reuters, the Associated Press, the New York Times, the Washington Post, and the Wall Street Journal provide thorough, fact-checked reporting on immigration policy and court cases. Be cautious about information shared on social media, as it can be outdated, inaccurate, or taken out of context. If you see a claim about a new court order or policy change, verify it with an official source or a trusted legal professional before taking action. Let me walk you through a couple of scenarios to illustrate how this court order might play out in real life. Imagine you are someone who has been living in the United States for 15 years. You entered without authorization, but you have built a life here. You have 2 children who are U.S. citizens, you have been employed, you pay taxes, and you have no criminal record. A few months ago, you were arrested by ICE in a worksite enforcement operation. You were placed in removal proceedings, and you filed an application for cancellation of removal, which is a form of relief available to certain individuals who can demonstrate exceptional and extremely unusual hardship to a U.S. citizen or lawful permanent resident family member. Your hearing is scheduled for several months from now, but ICE issued a notice that you would be removed before that hearing. Under the court order we're discussing, if your case falls within the scope of the temporary restraining order, your physical removal would be paused until the court resolves the legal challenges. This gives you and your attorney time to prepare your case, gather evidence, and present your application for cancellation of removal to the immigration judge. However, this does not mean you are free to ignore the proceedings or that your case will automatically be granted. You still need to attend all hearings, comply with any conditions of release, and work with your attorney to build the strongest possible case. Now consider a different scenario. You are someone who was ordered removed 5 years ago after a full hearing in immigration court. You did not appeal the decision and the order became final. You have been living under the radar, trying to avoid detection, but recently you were arrested in an ICE operation. In this case, you likely would not be covered by the temporary restraining order because you have a final order of removal that went through the proper legal process and was not appealed. Your removal could proceed unless you or your attorney can identify a basis for a motion to reopen or a stay of removal based on new facts or changed circumstances. This is why it is so critical to understand the specifics of your own case and not to assume that a general court order applies to you without consulting a lawyer. Let's also talk about what this means for the broader immigration landscape. The legal battle over immigration enforcement is not new, but the intensity and scope of the current litigation reflect the significant policy shifts that have occurred since the change in administration. Courts have historically played a key role in checking executive power when it comes to immigration, particularly on questions of due process, statutory authority, and constitutional rights. The temporary restraining order we're discussing is part of a larger pattern of judicial review that will likely continue throughout 2026 and beyond. There are multiple cases working their way through the federal courts right now, challenging various aspects of the administration's immigration policies, including worksite enforcement, expedited removal procedures, restrictions on asylum eligibility, and changes to the public charge rule. Each of these cases could result in additional court orders, injunctions, or policy changes that affect different segments of the immigrant community. It's also important to understand the political and public dimension of this issue. Immigration enforcement is one of the most polarizing topics in American politics, and court rulings like this one often become flashpoints for debate. Supporters of stricter enforcement argue that the administration has the legal authority and the mandate to enforce immigration laws more vigorously, and they view judicial intervention as overreach. Advocates for immigrant rights argue that enforcement must be carried out in a manner that respects constitutional protections and human dignity, and they see court orders like this as essential safeguards against abuse. As someone navigating the immigration system, you may find yourself caught in the middle of these broader political battles. My advice is to focus on what you can control, which is your own case, your own preparation, and your own legal strategy. The politics will continue to shift, but your responsibility is to protect yourself and your family by staying informed, staying compliant with any court orders or hearing dates, and seeking professional guidance. Now, what should you not do in response to this court order? First, do not assume that you are safe from enforcement just because a court issued a temporary restraining order. As I explained, the order has limited scope and it can be appealed or modified. If you are in the United States without lawful status or with a pending case, you should continue to take precautions, know your rights if approached by immigration authorities, and have a plan in place for your family in case of detention. Second, do not ignore notices from USCIS, ICE, or the Immigration Court. Even if you believe the court order protects you, failing to respond to official correspondence or missing a hearing can result in serious consequences, including an in absentia removal order. Third, do not pay money to notarios, consultants, or unlicensed individuals who promise to take advantage of this court order to get you papers or stop your deportation. There are many scams targeting vulnerable immigrants, especially during times of legal uncertainty. Only work with licensed attorneys or accredited representatives recognized by the Board of Immigration Appeals. You can verify an attorney's credentials through your state bar association or through AILA. Let me also address the question of what happens next in this case. As of early February 2026, the temporary restraining order is in effect, but the government is expected to appeal. The case could go to a federal appeals court, and depending on the outcome there, it could potentially reach the Supreme Court. The timeline for these appeals is uncertain. In some cases, appellate courts act quickly, especially when there is a request for an emergency stay of a lower court's order. In other cases, the process can take months. During this time, individuals who are covered by the order should remain in close contact with their attorneys and monitor any updates. It's also possible that the parties could reach a settlement or that the administration could modify its enforcement policies in response to the court's concerns, which could render some aspects of the litigation moot. Immigration law is dynamic, and what is true today may change tomorrow, which is why ongoing communication with a legal professional is so important. I also want to take a moment to talk about the emotional and psychological toll of living in this kind of uncertainty. If you are someone who is in removal proceedings, or if you have family members who are, I know this is an incredibly stressful time. The fear of separation, the financial burden of legal fees, the difficulty of navigating a complex and often opaque system, all of this takes a toll. It's important to take care of your mental and emotional health. Reach out to community organizations, faith-based groups, or mental health services that understand the unique challenges faced by immigrant families. Many communities have support networks specifically for individuals in immigration proceedings. You are not alone, and there are people and organizations that want to help. For those of you who are watching this and who have lawful status, or who are U.S. citizens, I encourage you to stay informed about immigration policy and to support the immigrant members of your community. This might mean connecting people with legal resources, volunteering with organizations that provide assistance, or simply being a source of accurate information in a time when misinformation spreads quickly. The immigration system affects millions of people, and the decisions made in courtrooms and in policy debates have real human consequences. Before I wrap up, let me give you a few more practical steps you can take right now, regardless of your specific situation. First, create a family preparedness plan. This means making sure that family members know what to do if you are detained, including who to call, where important documents are kept, and how to care for children or dependents. Organizations like the Immigrant Legal Resource Center and the National Immigration Law Center have free resources and guides on family preparedness that you can download and review. Second, know your rights. If you are approached by immigration authorities, you have the right to remain silent, the right to speak with an attorney before answering questions, and in most cases, the right to refuse entry to your home without a judicial warrant. Carry a Know Your Rights card with you, and make sure your family members understand these rights as well. Third, keep your documents organized and accessible. This includes passports, birth certificates, marriage certificates, immigration paperwork, proof of residence, employment records, tax returns, and any correspondence from USCIS or the Immigration Court. Having these documents ready can make a significant difference if you need to quickly consult with an attorney or respond to a legal development. Finally, I want to remind you that while this court order is significant, it is not a comprehensive solution to the challenges facing the immigrant community. Real, lasting change will require legislative action, and that means comprehensive immigration reform that addresses the millions of people living in legal limbo, creates pathways to legal status for those who qualify, and ensures that enforcement is carried out fairly and humanely. Advocacy, civic engagement, and supporting organizations that fight for immigrant rights are all part of the long-term work that needs to happen. As of today, February 5th, 2026, this is where things stand. A federal judge has issued a temporary restraining order blocking certain deportation operations under the Trump administration. The order provides temporary relief for some individuals with pending cases and raises important legal questions about due process and the limits of executive authority. If you are affected by this order, or if you think you might be, consult with a qualified immigration attorney immediately. Stay informed through credible sources and take the practical steps I've outlined to protect yourself and your family. This is not the end of the story. The legal battle will continue, policies will evolve, and new developments will emerge. That's why it's so important to stay connected to reliable information and to seek professional guidance for your specific situation. This video is for informational purposes only and does not constitute legal advice. Immigration policy can change rapidly and every case is unique. I strongly encourage you to consult official sources such as USCIS, the Executive Office for Immigration Review, and U.S. Customs and Border Protection, and to work with a qualified immigration attorney or accredited representative for guidance specific to your situation. If you found this video helpful, please give it a thumbs up, share it with anyone who might benefit, and subscribe to Immigration News Today so you don't miss our daily updates on immigration policy, court rulings, and changes that affect you and your community. Check the description below for links to official resources and organizations that can help. I'm here to keep you informed, empowered, and prepared. Thank you for watching, and take care of yourself and your loved ones.